Hello, welcome to today's immigration tidbit. A lot of times people just want to go right up to the top and appeal or make their arguments without doing everything before it gets there. For example, let's say they have some kind of constitutional argument that their constitutional rights were violated, and they know they don't want to argue that to the immigration judge or the BIA, the Board of Immigration Appeals. They just want to jump right to the Circuit Court of Appeals because they know the reality is that that's the first level that's going to be able to hear their particular argument. Well, let me tell you what happens if you do that. If you just jump right up, for example, to the Ninth Circuit Court of Appeals, let's say you're in Oregon or California or Hawaii, and you say, I know that the underlying courts and administrative agencies can't rule on this, so I'm jumping right up to you guys so you can make a rule to determine whether or not my rights were violated. If that is done, the first thing that's going to happen is they're going to say denied because of lack of administrative remedies, lack of exhaustion of administrative remedies. What does that mean? Well, there is a rule that when you have an agency that is an administration of something other than judicial, okay, when you go to court, when you go to the Ninth Circuit, go to federal courts, things like that, cases that are, and judges that are appointed by the president and so forth, those are judicial. However, when you have an agency such as the Immigration and Nationality Act, which they have to follow, there's all kinds of procedures that need to be done before it gets up to the Circuit Court of Appeals. And what happens is if you don't do that, they'll deny it right away without even ruling on the merits of the case. They will not say whether you would have won or whether you have a good case. No, they will just say you didn't exhaust your administrative remedies, denied. Okay, and if you do that, you're going to have lost the timeline to do the administrative remedies, so you're going to doubly lose. So you have to follow all of the necessary appellate procedures to get up there, even though you know, for example, the one I'm giving you on these constitutional arguments, you cannot possibly receive a ruling on it at the immigration court or the Board of Immigration Appeals. They will flat out say they don't have the authority to rule on constitutional issues. You still have to make the arguments. You still have to go and do the appeals. Okay, there's a procedure, and the reason for this is sometimes it'll be resolved before it gets to the Ninth Circuit or the Eighth Circuit or wherever you happen to be. And if it's not done, and not done properly, what would happen, the reality is it would clog the Circuit Courts of Appeal. Okay, think about it. Immigration is just one area that has a whole plethora of laws and procedures that the administration of that agency needs to engage in. Another would be IRS, okay, the Internal Revenue Service. Others are federal criminal laws. There's all kinds. There's the EPA, the Environmental Protection Agency. There's a litany that has to follow those procedures. And it really makes sense. Why? Because even though you feel you might be wasting your time and it takes a long time to get up there, if you had every agency across the United States forget, their procedures and just jump up to the real powerful courts, the Circuit Courts of Appeal, they would absolutely be backlogged and nothing would ever get done. So it makes sense for the use of judicial resources to be able to have to do that. So if you have something you're fighting, an immigration law, you have to follow the procedures and go up the ladder before you get to the real big judicial guns that will rule and maybe reverse the decision of the immigration judge. Okay.